All right. Good afternoon once again, everybody. Thank you very much for taking time out of your day to join us for this webinar, which is on personal data protection and direct marketing, kindly organized by the Tanzania Privacy Professionals Association. I do believe we have quite a number of participants who have joined, so thank you very much. My name is Abdulrahman Hussein. I'm the head of cybersecurity at Softec. I'm currently working on data protection solution for sensitive data discovery, classification, masking, anonymization, etc. Today we will hear from 3 specialists on data protection around the continent. Before we start, please let me invite Josephina.
Hello, good afternoon, everyone. So I'm gonna put on my camera so it doesn't seem like you're talking to a machine. So here I am. So my name is Josephina Nshunju. I'm a representative of the Tanzania Privacy Professional Association, or in short form, we are TPPA. So TTPA, I'm here to shortly introduce TTPA and what we do, and then I'll allow the moderator and the panelists to continue with the webinar session. So I would first of all welcome you all and thank you for taking your time out this afternoon to join us on this webinar. So TTPA is a collaborative association of privacy professionals, technology, AI, cybersecurity. And so we are an association that is dedicated in advancing data privacy and data protection standards in Tanzania. We work with different organizations, professionals, students, policymakers to promote best practices in personal data management and data governance, ensuring compliance and fostering trust in this rapidly evolving digital landscape. Through trainings, resources, and industry partnerships, TTPA hopes to drive awareness and help shape Tanzania's privacy framework. We're excited to support in this important discussion today, and we are hoping that you will get the most out of this session. We have monthly webinars. We try to have as many as possible throughout the year. TTPA is about a year old now. We are growing slowly and steadily. We operate in a membership style. So if you're interested to be a member of TTPA, we have a registration process. As the webinar is continuing, a member of our team will be sharing links to our social media platforms, as well as registration requirements. We have frequently asked questions, flyer that will be shared in the chat as well as the webinar is going on. If you have questions, feel free to contact us. I think they will also share the contact number if you have any further questions, if you want to understand how to become a member, what are the different membership groups that we have. We also invite organizational partnership. If there are companies that want to partner with us, we invite those partnerships. We also invite corporate membership as well. We have packages for corporate members that want to join the association as well. We will soon be hosting our first annual general meeting for all our subscribed members. So for all those who are registered members, communication will be sent to them. If you desire to become a member, to be able to have access to exclusive information, exclusive access to training and other opportunities within TPPA, we welcome you to contact us. We are in discussion with a number of training partners across the continent and internationally as well in Europe. So we have great things coming ahead, especially in the coming year. We are preparing for that. But for now, I would welcome the moderator to continue with this session and start the webinar. Thank you.
Thank you very much, Josephina, for that introduction. So we'll get right into it. Following the coming into force of the Tanzanian Personal Data Protection Act, There's been several debates and questions regarding the ambiguity or the lack of provisions that cover different aspects of data protection and privacy rights. Like many other countries, Tanzania's PDPA Act is also highly influenced by the GDPR from the European Union and other jurisdictional laws that were enacted beforehand. In today's webinar, we want to draw your attention to and dive into a discussion around personal data protection and especially direct marketing. We encourage you very much to actively participate through this webinar and feel free to ask questions in the chat. We'll do our best to address them during Q&A sessions, and we, of course, going to be recording this as you've seen. And later, this will be up on our social media. It is our goal by the end of this webinar that we have a better understanding of the provisions discussed here, as well as enhance your knowledge on data privacy. So I'm going to ask our speakers today to briefly come on and introduce themselves. We have 3 privacy professionals from around the continent. First one being Ms. Dorcas Tsebee. Kindly, Dorcas, if you're online with us, please do come on, unmute yourself and introduce yourself so that the rest of us know a little bit more about you.
Hi everyone, can you hear me?
Yes, we can. Yes, we can. Please, for the benefit of everybody, if you don't mind putting your webcam on, so at least they can get to see you.
Okay, I'll do that as it. But let me just thanks. My name is Dorcas Tsebee. I'm a privacy professional practicing in Nigeria, but I work across different jurisdictions in Africa and beyond Africa as well, but currently residing in Nigeria. My day-to-day is basically advising clients on compliance, data protection law, cybersecurity. Cybersecurity, there's also AI governance, startup advisory, and all other compliance issues that most startups have now, right? So the topic actually relates to me very well because part of what I advise on is data subject rights, and also assisting clients, different organizations managing data subject rights in their organization. So I'm looking forward to this conversation and also contributing to based on my experience in this space. Thank you very much.
Thank you very much, Dorcas, for that introduction. Secondly, we are also joined by Mr. Mrisho Swetu from Tanzania. Mr. Mrisho has been a member of the TPPA, and I'm sure he can tell you a little bit more about himself shortly. Karibu, Mrisho.
Yes, hi to everyone. Do you hear me?
Yes, please.
Yes, my name is Mrisho Swetu, based in Dar es Salaam, Tanzania. I'm also a TPPA representative. Currently, also, I'm working to assist the corporate to navigate the compliance following the enactment of Data Protection Act 2022. So the topic is familiar because when we speak to direct marketing, they have an implication to the personal information relating to an individual.
Thank you very much. Thank you very much, Mrisho. Sorry about that. And then lastly, we are joined by Ms. Winnie from Kenya. Winnie, are you able to hear us? Winnie, are you there?
Hi, I'm here. Can you hear me?
Yes, loud and clear. Please, if you can introduce yourself.
Okay, great. So, Winnie Ngige, based in Kenya, I handle data protection compliance services for a couple of companies, and I'm happy to be here today.
Okay, so thank you very much to our panelists. As I mentioned before, guys, if you have any questions, please do feel free to message in the group, and one of the team will collate them, and then we can take a look at the Q&A section. The format of the webinar will be about 30 minutes of discussion on several topics, and our panelists will be addressing those. And then we'll jump into your questions after that. So from our first speaker, I'd like to focus on Dorcas. Maybe Dorcas, if you can share from your experience in the Nigeria space and perhaps in the regional space where you've worked, how does the Nigeria's data subject rights influence the direct marketing practices? And more importantly, maybe you can share what common pitfalls that organizations in Nigeria face when trying to comply with data protection laws in their marketing efforts as well.
Okay, thank you very much for your question. Yeah, so when we think about direct marketing, first thing that comes to mind is DSR, data subject rights. And for the Nigerian legal framework, as well as a lot of other jurisdictions across Africa, since the laws are mostly similar, in relation to direct marketing hinges on consent. And what the laws provide, I'll first of all talk about the laws in Nigeria. So currently in Nigeria, the legal framework for data protection in Nigeria, there's the Data Protection Act, and then there are also subsidiary regulations that also are still applicable to data subject rights and data processing generally. So we have the Nigerian Data Protection Regulation, the Nigerian Data Protection Regulation Implementation Framework, and then there's also a draft general application guide that is currently being deliberated upon. So what these frameworks provide for is, in terms of, and in relation to direct marketing, first of all, hinges on consent. So it's one of the processing activities that require consent of the data subject. So you have to, in order to process personal data for direct marketing, you need to obtain consent from data subjects. And once consent is involved, it becomes really tricky, because it means that the right to objection is also triggered, because when a data subject decides to object to that processing, it means that you have to immediately stop the processing, and there is no exception to that. And that is also provided as a data subject right, and that's the right to objection. So once you have objected on the grounds of direct marketing, processing would have to be paused immediately. And then in relation to consent, again, if when consent is the lawful basis of processing, there's also the withdrawal of consent. So they see that right under the Nigerian law, there is a right called the withdrawal of consent. So you have the right to withdraw consent at any time once consent is the lawful basis for processing. So if a data subject or a customer or whoever their data is being processed by organization decides to withdraw consent, then you have to immediately stop that processing. If it is a picture that has been posted on your website or social media handle, you have to take that down immediately. Consent has been withdrawn. And what the law requires is that the withdrawal of consent should be as easy as it is to give consent. So if you are provided a mechanism or a medium for someone to opt in or to accept or agree to something, and then withdrawal is taking them through multiple steps, that you're already in violation of the law, because it has to be very easy. So you have to implement a very easy procedure for that. So what this means is that, going down to the pitfalls, is that you have to implement a consent management mechanism on your website. So consent management, there are different platforms for consent management, right? So what organizations struggle with is, first of all, obtaining explicit consent, recording consent, maintaining a record of consent, and also being able to communicate clearly to the users about the processing activity or whatever it is that they're doing. So most times platforms or websites or for different organizations don't really communicate clearly, right? And once consent is involved, you have to be as clear as possible, and resources would come in, because if you're going to implement a consent management mechanism on your platform, you have to put in a little amount to be able to set that up. So organizations struggle with that, struggle with managing consent, recording consent, and also for cookies, because tracking technologies are a medium of, are a mechanism for direct marketing. That those are like the facilitators of direct marketing. So if you have cookies or other tracking technologies on your website and that are collecting data, which will be later used for direct marketing, it means that you have to also obtain consent and then set a preference mechanism for data subjects to be able to select or consent to the use of cookies on the website, and then select their preferences as well. So you're able to track across different platforms. So in my experience, organizations struggle with that. So this is why they now have to rely on tools, consent management platforms, to be able to effectively manage consent and keep a record of the consent as the law requires as part of your accountability documentation obligations. So you're maintaining that consent. Then when there is a withdrawal, when someone has withdrawn their consent to a particular processing activity, that has been recorded and it's also noted. So, and it is always advisable to suppress the data instead of deletion, because deletion, it could be that data is still stored elsewhere and it can still be used for the same marketing. So you find out that most times when you have withdrawn consent or you've opted out of something, you're still getting those emails. So it's also being able to accurately or effectively track where the data is stored across different platforms, and then being able to actually suppress that marketing communication. So I think these are like some of the things that organizations struggle with, and then they have to rely on tools or consult professionals to be able to adequately address those concerns. So that's my thoughts on that.
Okay, I hear you, Dorcas. I think definitely in terms of challenges, technology and technological controls, as it were, especially when it comes to around consent collection and consent management, especially on websites, can be very, very difficult. First of all, I think there's the whole technical challenge of how you're tracking the individual's data subject data subject themselves, and how it's a balance between loading the website and getting that consent. So thank you very much for that contribution, Dorcas. Maybe just to say, to set the scene for everybody else who perhaps is not familiar. Direct marketing is essentially the strategy that companies employ, which involves communicating directly with potential customers, or even potential customers, to encourage some kind of response or some kind of action. So most of us have received a email marketing newsletter or some kind of flyer, whether we've consented or not. There's telemarketing. I'm sure we've all received calls or text messages to join certain subscriptions or for different services. And of course, there's direct marketing, but also the tailored online adverts. And I think that the tracking there is a lot more, and we're seeing more and more technological providers be able to provide controls to stop the tracking. I think ultimately the idea is that, of course, the connection, they're trying to create this personal connection with the audience, having sort of tailored messages based on data they've collected in the past. I'd like to now move on to Mrisho. Mrisho, if you can please share with us, what are the regulatory requirements in the context of direct marketing in Tanzania, especially when the law has just recently been passed, but also we are not quite there yet in terms of the regulations that are supposed to underpin that law. And then maybe you can also share in terms of the perception of data monetization here in Tanzania.
Okay, following the enactment of Personal Data Protection Act in 2022, it has also an implication when it comes to direct marketing. When you read the act itself has already clarified what is direct marketing. It means it includes the communication by whatever means of an advertising or marketing materials which is directed to an individual. As you said, it can be through an email, it can be short message services, SMS, it can be through automated calling ads and other forms of direct marketing. So starting with the regulatory requirements for compliance, data protection compliance in the context of direct marketing, you need to consider yourself if you are following under the controller or data processor. So if you are data controller or data processor, you need to register before the commission, Personal Data Protection Commission. Then you are also responsible to comply with all the data protection principles when you are processing data for the marketing purpose. You need to keep the data subject informed about the data processing for marketing purpose. You inform the data subject maybe through privacy notice. You need to tell them what the data will be used, how, and for what purpose. If for marketing, you need to tell them also. Consider to have a legal ground also for your data processing for marketing purpose. If you are using consent and the consent is appropriate in this circumstance, then you need to make sure that the consent is valid in the eyes of law. Also, consider to put the data subject at the center, means give the data subject control over their data. Make sure you handle all data subject access requests when it comes to direct marketing. For instance, right to withdraw consent, if they exercise their right to object, and maybe a right to prevent data processing for marketing purposes. So all those are accountabilities provided under the Data Protection Act of 2022 need to be complied with. A data controller or data processor need to implement privacy by design by default, ensure there are available technical and organizational measures for data processing in the context of direct marketing. So for the case of data monetization, it is a concept that has been introduced in many in different jurisdictions. So when you say data monetization, it is an act of generating a visible economic benefit from available data sources. It can be selling data, a company may sell data maybe to the other company for the purpose of generating revenue. However, that jurisdiction goes far even entering into the contract with the data subject. For instance, a controller may enter into the contract with the data subject maybe to use the information for pecuniary gain. So, for instance, Abdul, you can enter a contract with maybe software. The software can use your information maybe for the marketing purpose, but for the aim of what pecuniary gain. So when you read the Personal Data Protection Act in Tanzania, it has provided a room for a data subject to enter into the contract with a data controller to use that information or process the personal information related to data subject for the purpose of what pecuniary gain. So all the concept of data monetization seems to be incompleted in the act, but with limited. Limited means that a data subject can enter into the contract with the data controller to use the information or process for the pecuniary gain.
Okay. Thank you, Mrisho. Just to maybe follow up on that. In Tanzania, we are very much used to, when you visit a particular building, you're supposed to supply your name, your phone number, the office that you're visiting, etc. Within the current law and regulations, what kind of protection or what kind of rights do the data subjects have in that kind of case where where that book, that security book, can be sold, and someone could use your information for marketing purposes.
Or in Tanzania, selling of the personal information is prohibited by the law. You are not allowed to sell the personal information related to a data subject, maybe for another company. However, data monetization is a huge concept. It extends even to selling of the information. However, also a contract with the data subject and data controller for the use of the information for the direct marketing is also considered to be a monetization. So the scenario you are saying here in Tanzania is not allowed unless otherwise you are complying with the Personal Data Protection Act in Tanzania.
Okay, thank you for that answer, Mrisho. We'll come back to this discussion at a later point. I'd now like to move on to Ms. Winnie. And Winnie, if you can kindly tell us, share with us, what are the most significant regulations that are governing personal data protection over in Kenya that the marketers really need to be aware of? And then if you can also provide some examples of how businesses in Kenya are successfully integrating compliance into their direct marketing strategies.
Thank you for that. So in Kenya, the regulatory framework, we have the Data Protection Act of 2019, as well as the Data Protection Regulations of 2021. So we have the general regulations, which speak more to the provisions of the Data Protection Act, as well as the Data Protection Regulations on registrations of controllers and processors, as well as the regulations on enforcement. So in terms of direct marketing within the Kenyan context, it's pretty much similar to that of Nigeria and Tanzania in that you need to obtain consent from a data subject before you use their data for marketing purposes. In terms of what companies are doing to stay compliant, I think this is an area that is still in development. What I have seen from my experience is companies are creating their own consent management framework. So this can be in form of Excel sheets or technology means maybe the One Trust and the like that are there in the market. But it's still an area that is causing a lot of problems, because if you do not have a way to track when consent was obtained or when it was withdrawn, then it is difficult for you to know which client has objected to the processing of their data for marketing purposes. So this is still an area that we are yet to see growth and compliance within that sector. If you can even look at the enforcement notices that have been issued by the Office of the Data Protection Commissioner, you can see that most organizations are not even able to demonstrate that they obtained the necessary consent to send people marketing communications. And even when they receive requests for withdrawal, they're not able to validate the same or to enforce the same. So this becomes quite a challenging issue. And you've seen many companies having to either pay penalty notices or to compensate data subjects for using their data for commercial or for direct marketing purposes. So it's still a growing area for us as a country.
Okay. Thank you, Winnie. So maybe I can just follow up question to what you have just said. So I hear you that that marketers are creating some kind of their own sort of consent management frameworks. So maybe how does the regulator ensure the compliance, or if they're conducting audits, if the marketers themselves don't have a standardized format for consent records and consent and how that consent record is documented? Or maybe you can share what. Yes, please, go ahead.
I'd say the approach by the data commissioner is very ad hoc, in that it's not very, I'd say, structured on who to go for in terms of auditing for purposes of use of data for commercial purposes. So they are yes doing audits, but this is based on sectors. So they're doing audits for the financial sector, for the education sector, for the healthcare sector. It's yet to roll out to organizations that are wholly or partly involved in digital marketing exercise. So there isn't really much going on in that particular sector. We also do not have specific guidelines, regulations that can govern organizations that are mostly handling marketing communications. For example, most organizations use marketing agencies to run their SMS blast or their campaign blast, but then there's no one to really provide proper guidance on what constitutes marketing communications. For instance, if you reaching out to our clients or viewers telling them that you have an additional service amongst a marketing exercise, or is it just you informing them of the new services that you have? So unless we have a proper regulation in place or a proper guideline that would guide that sector, I see a situation where most companies are going to find themselves in a lot of the trouble with the data commissioner, because most most data subjects are now just getting aware of their data protection rights, of their privacy rights, and they're going hard on companies on how they're using their data for marketing purposes, even when that client is a customer of the company. So unless we have a proper guideline, is going to continue to be a great area of concern.
Yeah, certainly, and it'll be interesting to see how that will unfold. I'd like to now move back to Dorcas, and if I can ask you, Dorcas, if you can share insights, almost in a similar line to the question that Winnie was just addressing. So if you can share insights on the balance between effective marketing strategies and the necessity of adhering to data protection regulations in Nigeria specifically.
Okay, you're asking strategies to balance marketing and data protection, right?
Yes.
Or
adherence to the regulations.
Okay, adherence to regulations. Yeah. So one thing that came to mind when I was going through this is that, so beyond data protection, right, just an aside to also mention in terms of practice, beyond data protection, marketers and organizations should also pay attention to other regulations on consumer protection. It's also very important because compliance with especially marketing that is sector specific, because it relates to consumers generally and not just maybe like practices in relation to consumers, how you're dealing with data, and even beyond data, other information as well. It is important to pay attention to marketing strategies. Is your marketing fair? And even promotional activities. You're using testimonials from existing customers. Customers that have used your service. You're using the testimonials on your website. There are other laws that also govern these things and how you're approaching it and how you're obtaining permission. So it's important to have that in mind when embarking on marketing campaigns. So beyond just looking at data protection, also looking at broader provisions on consumer protection as well, ensuring that whatever content you're putting or communication that you're sending to customers or prospective customers is fair and is also the accurate state of things in relation to the service that you're putting forward. So that's on the side. Then for marketing strategy in relation to data protection, like I mentioned earlier, content management is key. Being able to clearly communicate your marketing, whatever it is that you're communicating to the customers. Your first communication there should be a lawful basis for that. So you're not just sending unsolicited marketing communication to customers without a lawful basis, because that would amount to unlawful processing. So you should be able to have a lawful basis, and in this case for Nigeria, the lawful basis is consent. So you've already obtained consent for that, and then you've sent your email or your message or SMS, however, whatever medium that you're using to communicate. You've sent that, and then you've also communicated, and there's also an opt-out option there. So they are able to click on a button, and the opt-out option works. So what we usually advise clients is to make sure that your consent withdrawal mechanism actually works. So you don't just have a button that takes customers round the page, and it does not eventually remove their data from your system. So you have that in place where there is a working mechanism. And there's also, if they are going to withdraw consent via an email, you make sure that email actually also works. So if a message has been sent to an email address, it's not that the emails are never checked. There's no auditing to see what messages have been sent. There's no record of anything. So organizations would then ensure that they are putting that in place. And once all of that is checked, and you're also sure that your marketing complies with all applicable regulations, you're able to also get the benefit from your marketing campaign, because businesses, of course, they exist to make profits. So having that in place, and for organizations that can afford it, it's good to have a data protection person in your organization, a data protection officer that sort of checks, that liaises with marketing departments or other departments that are responsible for marketing, to ensure that whatever you are putting out is clear. And if you're going to undergo direct marketing or any targeted advertisements or whatever, you've had the compliance requirements checks, which I've just mentioned. So having a lawful basis, communicating clearly, clear communication is very important. And if you have a consent mechanism, it is also good to include your privacy notice. The importance of a privacy notice is that it sort of tells the customers how you're going to use their data. And if it's a situation where the data is going to be retained for a very long period, you also specify. Yep. Have I overshot?
Yeah. If you could wind up, please.
Okay. Yeah. So yeah, just about clear communication, and they knowing what that whole processing is about. Yeah.
Okay. I hear you. Thank you. So in the same line, Mrisho, what are the future trends that you foresee in the data protection and direct marketing here in Tanzania, and how should businesses prepare for them?
Okay, hello again.
Yeah.
So for the case of trends, we foresee to see that there should be a striking balance between direct marketing and privacy. So we are sure that marketing companies doing direct marketing to individuals, they would be in a position to ensure that there is a balance between the activities they are doing and the privacy of the data subject. Also, digital marketing tools should be also in compliance with data protection requirements of Tanzania and maybe other jurisdictions. For instance, if you are using an online solution to facilitate marketing, so the solution should be also compliant with the Tanzania Personal Data Protection. Okay. Marketers also would be required to operationalize privacy throughout their marketing activities, to implementing privacy by designing to ensure the available technical and the organizational measures and the other measures relating to data protection. Marketers also consider that users or data subjects also are active to protect themselves online. So have you heard about the concept of blocking ads, hiding browsing history? So these marketers should consider to facilitate the privacy of these data subjects when they are online. We expect also the marketing companies to comply with all data protection requirements provided under the specific data protection laws. I know also the consent management is also a challenge as we are starting now, but I'm sure all these data controllers and data processors who perform these activities relating to direct marketing, specifically to individuals, they will be complying with the new laws. TPPA, I know that the TPPA is on the front to influence the regulators, specifically the release of guidelines relevant to data protection and direct marketing. So in context of marketing purpose in Tanzania, we need also to have a specific guidelines to guide the data controllers and data processors. And I'm sure TPPA will work very well in this aspect. So for the best interest of the data controllers and the data processors in Tanzania.
Okay, thank you very much, Mrisho, for that contribution. Lastly, to address the last question to Winnie. Now, Winnie, most often times when people talk about data protection, they're really looking at the angle of the data subject and the rights in that, the rights are safeguarded and so on. Maybe if you can share what kind of challenges that you see for marketers in Kenya regarding the data protection compliance and how they can address these now from their angle as opposed to from the data subject themselves.
So from a Kenyan perspective, what I've seen as the biggest challenge in terms of responding to data subject requests within the stipulated timelines, depending on the right someone is trying to enable, which can go up to at least 30 days for you to respond as an organization. So the challenge is most companies are unable to respond within the stipulated timeline, and mostly it's because either they do not have a dedicated email where this request can be channeled through, or they do not have a specific individual that handles data subject rights. So this makes it a bit challenging to respond within the stipulated timelines, and if you don't respond within those timelines, then data subject has the right to complain to the Office of the Data Protection Commissioner. So from where I sit, my advice is always map out the areas, the different departments where I feel like requests can come through. For instance, most requests can come through the customer service email or platform that you use. So have someone that is always dedicated to look at those particular emails. Once you've done the mapping of the specific channels through which such complaints can come in, it makes your work a bit easier to identify what is a complaint and what is a data subject right. The other issue is in terms of verification. One of the challenges I have seen is verifying that the person who's asking you to maybe delete their data, to restrict their data, or to put their data, or provide information about a specific data set might not be the individual that shared this information with you. This is especially for data that belongs to children, where if you find that the parents maybe are not together for one or two reasons, then one of the parents is the one that shared this information with you. and then the other parent wants to also have information on the data that you have, then it becomes a bit challenging. So for that, I always say, always go with the person that gave you that data. So if you do not have the consent, or do not have authorization from the person that gave you that data, do not share it with any other third party. The other thing I'd say is always have a notification or a transparency framework within your whole data protection privacy framework. So you need to have a proper privacy policy that outlines what you're doing with personal data, including why you're using data for marketing purposes. It just makes it easier for someone to make a decision on whether they want to receive marketing communications from you or not. The other thing I'd say is make it a habit to audit your social media platforms, especially for companies that are using, say, employee images or images of customers based on a certain promotion. For instance, I think sometime, I think this month or last month, there's a company that found themselves on the wrong side of the Data Protection Act because they were running a campaign that was using, it was a Mother's Day campaign, and they used the data of someone's mother on a billboard without obtaining consent from her to use it for that particular purpose. So they found themselves having to pay compensation, which is something that could have been avoided. The other thing is when you're using stock images, always ensure that if there's a way you can obtain consent from a data subject, go through that route, because from the Kenyan perspective, there's a division where the data commissioner says that even if you're going to use stock images and you have the requisite copyrights to use that because you paid for that particular platform, you are still required to obtain consent from an individual. So this could pose a huge challenge for marketers. So maybe for now, we might have to revert to where you have a model, or you have to look for someone to advertise a product or a service for you.
So I see very interesting challenges that you have raised. You know, how do they go about it, and how organizations can look at putting steps into to be able to address this whole concern. So now I'd like to first of all thank the contributors. I'd like to open the floor to I'd like to open the webinar to the floor for questions. I can see that there is one from Fatma. Fatma is asking, I don't know who this needs to be addressed to, but Fatma is asking, can direct marketing be under another legal basis for processing personal data such as legitimate interest? I would, any one of the panel would like to take that? Please feel free to unmute yourself and go ahead.
Hi.
Yes, please.
So there's a question here on other legal basis for direct marketing, right?
Please.
Yes. So yes, there is legitimate interest, like you mentioned, but this is in relation to existing customers. So if a business or an organization wants to send direct marketing in relation to the existing customers, telling them about a new product or a service that would that is already connected to what they already offer them, yes, then you can rely on your legitimate business interest to send direct marketing communication to those existing customers. But if they're new customers, that's when you have to obtain consent to be able to send direct marketing.
Okay, thank you for that, Dorcas. The second question that we see is, what kind of information does an organization need in order to provide the service and send a newsletter, for example? Data minimization principle, maybe one speaker can, okay. This was directly to me. So what kind of information does an organization need in order to provide the service to send like a newsletter? Maybe Mrisho, if I can ask you to address this, particularly around the data minimization principle. Mrisho, are you with us? Seem to have lost Mrisho. Winnie, maybe you could address that one.
So for a newsletter, for respecting data minimization, I'd say you probably just need someone's name and their email address.
So if we look,
Sufficient.
sorry to cut you off. Go ahead, please.
Yeah, I'd say you probably just need someone's name, maybe even just their first name, their last name, and their email address. That should be sufficient for you to share a newsletter with them.
Okay. Of course, the principle of data minimization is that, of course, we need to collect the most minimal amount of information as possible from a data subject, so that we're able to provide the service itself. So I think Winnie's addressed that very, very clearly. For how long should you keep personal data obtained for marketing purposes? It's another question that's coming. Can I please ask one of the panelists to address that? Mrisho or Dorcas, one of you.
Yes, can you take the question again?
So the question is asking the data that we are collecting for the purpose of marketing. For example, you know what Winnie has just mentioned for newsletters or for other marketing purposes. How long should that data be kept? Is there a particular regulation that says exactly how long an organization is meant to be holding on to that data?
Not really. There's no particular regulation that specifies how long for direct marketing, because if it's newsletters, for example, depending on what kind of direct marketing, again, if it's newsletters that subscribe to it, you're keeping that data as long as you're sending marketing emails or marketing communication. So as soon as they withdraw consent, what the law has said is that the data should be deleted or suppressed immediately, so that you're not sending this in the marketing communication anymore. So as long as that purpose still exists, then the data will remain with the organization. But once you fulfill the purpose or you're done with the particular marketing and you have no need for the data anymore, then you can proceed to delete the data. Yeah, but in relation to market newsletters specifically, you keep processing that data as long as they've subscribed. Once they've unsubscribed, then they've withdrawn consent and you're mandated to delete.
Okay, thank you. Thank you very much. I think that's the last question we have, and I'm very, very conscious of the time. I'd like to kindly ask all the speakers maybe to just wrap up one key takeaway for 30 seconds. What are your key takeaways that, if anything, that they should take away? What would that be? Please, I'd like to invite Winnie first.
For me, the key takeaway is to have a profile of full basis, whether it's consent or legitimate interest, for using personal data for direct marketing or for commercial purposes. The other thing is documents. Whether you're using a software to document consent or you're using physical forms or Excel sheets, just document and you track with them. And the other thing is transparency. Always be transparent on your data processing activities. This just saves you a lot of pain and the headache where if you had shared information on how you're going to use data and someone consented, you can always use that evidence should Data Protection Authority come after you. So yeah, transparency, documents, and have a proper basis.
Thank you very much, Winnie. Dorcas, please, your key takeaway in less than 30 seconds.
Okay, my key takeaway is understanding the legal framework. It's very important to understand what the law says. Have a data protection person within the organization, someone who will champion privacy within the organization. Set up a framework, a privacy program framework if you can afford it, or something that just speaks to data protection and you're able to follow that in your practices. And lastly, training and awareness is very important. So training your staff on compliance requirements, procedures, and all that is very key.
I think you raised a very good point there, Dorcas, because you may have implemented all the frameworks under the sun, but if the people that work in your organization aren't aware of the procedures, aren't aware of the consequences, and what they're supposed to do, then it will all fall apart. So thank you very much for raising that point. Lastly, if Mrisho is back with us, Mrisho, are you there? Hi, Mrisho, can you hear us? Okay, it seems to be some technical issue, perhaps. I hope he's okay. At this point, I would like to wrap up in terms of the webinar portion. So thank you very much to our panelists today for the contributions that they have made. It is a very interesting conversation that we're having. It's a conversation that certainly requires a lot more time. I think 1 hour perhaps was not enough. Questions that our panelists have made today. I'm sure Josephine is saying that he is muted. Okay, let me see if I can ask him to unmute. I don't see him anymore. Apologies for that. Okay, so first of all, I was just thanking everyone, but in terms of what I got out of this was very well summed up by the speakers at the end. So in terms of legitimate interest for the data you're collecting, make sure that you have transparency and make sure that you have the proper document. But most importantly, that the team that you have in the organization is very, very well informed as to why they need to keep the data secure, as to why they should follow the procedures. So thank you very much. I'd like to invite Josephine from TPPA maybe to close for us, and she can tell us maybe what else is on the horizon in terms of webinars such as this, so that we have something to look forward to and what are the best ways to know more about it. Karibu, Josephine.
Asante. So thank you once again to our moderator Abdul and the whole panelist. It's been a very insightful session, and I believe our participants were able to take down some notes here and there. So one of our plans in TPPA is after webinars like this, we prepare a short summary or newsletter, which will be shared on our social media platform, including our group on WhatsApp. Like I mentioned in the introduction, these webinars are performed or they are monthly. We are yet to decide the topic for November's webinar, but that will be the last webinar for this year. And hopefully by the end of the year, we will roll out a calendar of the potential topics that we would like to cover in the coming year. As I mentioned, for our subscribed members, we will have the annual general meeting coming up where we will share our strategic plan for the next year and the coming 5 years. We also plan to share for our subscribed members the training opportunities that are in store in the coming year as well. But for the time being, I can't say much because there's still a lot that is in the works by our leaders. We also hope to select, of course, leadership teams during the AGM. And I would like to encourage all our TPPA members to come up to volunteer, to moderate. We encourage our members to be active in order for them to grow professionally, to get more visibility, not just in the Tanzania market, but also internationally as well. Like what you have done, Abdul, we applaud you for stepping up and joining us in moderating this session. It was a very wonderful. So thank you for the great work you've done today. So from TPPA, I would like to thank you and wish everybody a good evening and hope to see you again next month. We will send out posters and registration links. Our marketing team will do that and you will see it on our social media platforms. So thank you.
Thank you and have a good evening.